Good morning, everyone. Michael Selway and I are here to talk about restrictive covenants, to discuss principles, to discuss a very interesting, relatively recent case which made its way all the way up to the Supreme Court, which was the first time ever in almost 100 years since Section 84 of the Law of Property Act 1925 has been around that it's made it up to the highest court. So it's an interesting decision, and for reasons that I'll come to if you don't know the case, it's also a relatively sexy case by property standards as a result of the factual matrix giving rise to the dispute, which I'll take you through. But it's a very interesting case, not only from a factual perspective, but also from a principles-based perspective. I'm just going to set the scene before we get into the substantive slides. As the slide indicates, what we're here concerned with today is restrictive covenants that affect freehold land. Obviously, there's very different considerations in the leasehold context, and that's not what we're interested in today. At the risk of stating the obvious, the perspective coming from whether you're advising a client who has the benefit of a restrictive covenant or who has a burden or who is burdened by a restrictive covenant in terms of land use proposals will be very different because their perspectives will obviously conflict and compete with each other. There's also competing principles at stake. So on the side of the covenant, we've got private rights, upholding contract, and the legitimate interest of controlling adjacent land use when a party sells off part of their land. And on the other side of the equation, we've got the public policy of stifling the use of adjacent land. That's why Parliament intervened in this area. Up until recently, in the context, and we've seen it quite recently with COVID and interference in private rights in a commercial and even a residential leasehold context, it's not very normal for Parliament to intervene in the affairs of contracting parties. So Section 84, when it came about, was actually a very novel power and jurisdiction. So it's an important jurisdiction, but it has limits, and we'll come to those limits because it's not just a free-for-all where you can go to the Upper Tribunal and say, well, it's all very unfair. This covenant's preventing me from using my land. Can you please modify it or discharge the covenant? It's just not that easy. And understanding those limits is obviously important because it'll inform decision-making on both sides of the equation. It'll inform pre-action discussions and negotiations, and it'll inform strategy on whether to litigate or not in the Upper Tribunal. What we're not concerned with is interpretation or construction. The principles are relatively well settled anyways. It wouldn't be that interesting of a talk. Restrictive covenants, just like any other aspects of a contract, will need to be construed in accordance with ordinary principles. But we're not here to talk about matters of construction. We're also, save for an exception, as you can see from the slide, not here really to talk about enforceability. It's almost presumed for the purposes of today's talk that the covenant in issue is an enforceable covenant. That one exception, and I think it's an important exception because it's popped up quite a few times in practice for me. I'm sure it's popped up a few times for some of the attendees, and I think it's very important to be aware of. There's a difference, obviously, between registered land and unregistered land, and what needs to be done to protect a covenant is very different. But a number of covenants date back quite a few years. I've seen some that date back hundreds of years. And it's not unusual that at the time that the covenant was created, that the land was unregistered. And for it to be protected, it needed to be registered as a Class D2 land charge. And if it wasn't so registered, on the next conveyance to a purchaser for money or money's worth, the burden of that covenant is not only rendered void against that purchaser, it's rendered void for and unenforceable for all time. So it can't be cured by first registration of title. And that will happen from time to time, where on first registration, the land registry, because they're not interested in these types of dealings and whether it was registered validly as a Class D2 land charge. So they will, on first registration, they will from time to time put on or record the covenants, which are clear from the title position. But that doesn't necessarily mean that covenant is valid and enforceable. Because if it wasn't registered, as I said, as a Class D2 land charge, on that first conveyance after it was created for money or money's worth, it's rendered void and it can't be revived. That's not to say, and most practitioners in this area will know that you can have a chain of personal indemnity covenants, but all that will sound in is a monetary remedy, not a proprietary remedy. And not only that, the further along in time that we are from when the covenant was created, the less useful and powerful that tool is anyways in terms of a personal indemnity covenant. So it's just an important point to be aware of in terms of registration, because it pops up and it can be a killer point, and it can be a killer point right from the start. We're also not here to talk about annexation in terms of the benefit running with the land. There's quite a lot of law on that subject. So our hypothetical scenario is an enforceable covenant, validly annexed. The owner of the burdened land wishes to put his land or her land to some use. As properly construed, that covenant impedes that use or appears to impede that use. And the threshold question for us is, can the covenant be modified or discharged in the event that the agreement cannot be reached between parties? So as I said, the prospects of modification and discharge will not only be important to the decision whether to litigate the decision-making process before deciding to issue. In terms of a structure for today, Michael will discuss and talk to the jurisdiction to modify or discharge. There's four well-known grounds, and compensation is an important feature of the Section 84 jurisdiction. So Michael will speak to that. He will also have a few words on procedure. I'm then going to look a bit more at the most important ground, which is ground AA. And what I'm going to be focusing on is the so-called public interest test, as we'll come to discuss. And as you probably already know, ground AA covers two things, the so-called limited benefit test and the public interest test. And I'm going to focus on the latter. I'm then going to discuss this recent Supreme Court decision and take you through the history of that case from the Upper Tribunal through to the Court of Appeal to the Supreme Court. And then I'm going to finish discussing some discernible trends and some recent Upper Tribunal cases. So I'm going to pass over to Michael.
Thank you, Jay. And I'm going to start by introducing the main provision of the section, which is summarized and simplified, hopefully, on this slide. We're talking about Section 84 of the Law of Property Act 1925, and in essence, what that says is that the Upper Tribunal has power on the application of a person interested in freehold land affected by a restricted covenant to order the discharge or modification of such a covenant upon being satisfied that the case in question falls within one or more specified grounds, and the tribunal may also direct the payment of certain compensation. I don't know if Jay can switch over to the next slide for me. I'm talking about a particular context here, but there are some other contexts in which this power can be relevant. The particular context that Jay's introduced is where an applicant wants to undertake some development or activity on their land, subject to, but that land is subject to a restrictive covenant which impedes that development or activity. The situation can also arise, in a sense, in the from the other way around, whereby an applicant maybe has started undertaking a development or activity which would be impeded by the restrictive covenant, or is intending to, and the person with the benefit of that covenant brings injunction proceedings to stop the applicant's development or activity. And in those circumstances, the injunction proceedings will be brought in court, but the applicant can ask the court to stay the injunction proceedings and bring an application in the tribunal for discharge or modification, because it's the tribunal that has the power to discharge or modify. The court doesn't have that power as such, but the court does have the ability to allow an applicant to make an application to see if the covenant will be discharged or modified before deciding on the injunction proceedings. So it can arise in that context as well. And I've also mentioned on that slide section 84.2. That refers to declarations rather than discharge or modification. And that occurs in the slightly different context, which Jay has sort of foreshadowed, which is where a person has land burdened by a restrictive covenant, or potentially burdened by a restrictive covenant, but in fact they think they've got an argument that it isn't burdened by that covenant, perhaps because the benefit hasn't run, perhaps because they think the covenant has lapsed, perhaps because they think the covenant doesn't cover the development that they're intending to undertake. And in those circumstances, they may not need to discharge or modify the covenant, but they may want a declaration from the court, because it's the court that has power under section 84.2, not the tribunal. They may want a declaration from the court that their development can go ahead without breaching the covenant. So depending on what circumstances a person is in, will determine one of a number of proceedings that they may wish to take, whether that be making an application, defending injunction proceedings by making an application, or perhaps not making an application to the tribunal, but actually seeking a declaration from the court as to the effect of their covenant, or perhaps even a combination of the two or three. The jurisdiction is, as I've said, for discharging or modification, the jurisdiction is in the Upper Tribunal, not the court. It affects freehold land, or relates to freehold land. There is a limited leasehold jurisdiction under section 84, but we're not dealing with that today. We're looking at freehold land. And the jurisdiction is over restrictive covenants, not positive covenants. The tribunal doesn't have jurisdiction to modify or discharge positive covenants. The application can be made by a person interested in the burdened land. That can be a legal or an equitable interest. Potentially can include a purchaser of the land under a contract to sale. It can also include the original covenantor. So the person who originally entered into the covenant can actually apply to have it modified or discharged, although they may find it more difficult to succeed, but they can do it, they can apply. The wording of section 84, which is slightly more difficult than the hopefully simplified version that I included on the first slide, actually refers to covenants relating to the user of land or building on the land. However, that's been widely interpreted. So user may include restrictive covenants that restrict things that you may not think necessarily on the face of it are user, but may be encompassed by this power to modify or discharge the covenants. As I say, it's been widely interpreted, but it's perhaps not unlimited. So it may be a point to check in some cases as to whether the covenant that you're dealing with actually falls within use or building, such as that the tribunal has power to discharge or modify. The covenant should be enforceable. Jay has mentioned that we're not dealing with whether a covenant is whether the burden or the benefit have run with the land, whether a covenant might be unenforceable because it's lapsed, for example, or because it's personal and that person has left the land. And there may be a question, as Jay indicated, as to whether properly interpreted the covenant prohibits the use of the land that's sought to be made. The tribunal only has power, or will only exercise that power, to discharge or modify covenants where the land is affected by the restricted covenant. It uses the word affected. And if the covenant no longer burdens the land, or if it's lapsed, or if it was personal, then it will no longer affect the land. If there's a question of interpretation, then it may still affect the land, but when we move on to the next stage of considering whether a discharge or modification is needed, it won't be needed. So we're not dealing with enforceability today, but that is a requirement for the tribunal to act under Section 84(1). There's also some limited areas where the power to discharge or modify has been excluded, both under Section 84 and under other statutes, but I'm not going to go into detail about that. Just one final point about the enforceability, while on this slide, I mentioned Section 84(2) about seeking declarations. There may be some overlap there between questions as to whether the benefit and burden has run, whether the covenant has lapsed and so on, which could be dealt with under Section 84(2) by an application to the court seeking a declaration that your development isn't going to be inhibited by the covenant. That's one option, but it's also possible to for the tribunal, in deciding whether it has jurisdiction, to make decisions as to whether covenants are enforceable. It may make the decision itself. It may suspend its proceedings to allow a person to make an application to court under Section 84(2). The circumstances of the case will determine what is the most appropriate procedure in a particular case, and it's something that needs to be that should be considered in a particular case as to what is the appropriate procedure. Should it be an application to court? Should it be an application to the tribunal? And some applications to the tribunal therefore actually assert, somewhat counterintuitively, that the tribunal may not have jurisdiction over a particular case because they think that the covenant in fact has lapsed or the burden hasn't run. But nevertheless, they seek for it to be modified or discharged. And in those cases, the tribunal will have to deal with that or consider on what circumstances it's willing to accept jurisdiction or not. Before moving on to look at the grounds and the exercise of the tribunal's discretion under Section 84(1), I'll mention a few alternatives, because it may be that an application isn't necessary. If all the people interested in the covenant are available, known, have capacity, and agree to discharge or modify a covenant, then that can be done by way of an agreement and a properly drafted, executed and registered deed. That may avoid the need to rely on Section 84, but there may be difficulties in many cases in identifying all the people that need to be bound into that deed. So that may not always be available. Insurance is another possibility. It may be possible in some cases, particularly if there's low risk of enforcement of the covenant, to insure rather than incur the expense of proceedings in the tribunal or indeed in court. And I've mentioned enforcement risk. There may be a question as to whether any land still exists that is benefiting from the land, or whether the people owning potentially benefited land actually know that they might have the benefit of the covenant. And in those cases, there is a question to consider, albeit a risk involved, and this might well often be I was asked about insure against what? Insure against potential enforcement of the covenant. It may be that a piece of land can be, if a piece of land is being developed, that insurance can be taken out to protect against the risk of enforcement of the covenant, so that if it is enforced, there's some protection there. But as I say, that may only be appropriate where the risk of enforcement is relatively low, and that feeds on to that question about enforcement risk. If there is a low risk that the covenant might be enforced, then there may be a question as to whether, with insurance as appropriate, a development can go ahead without an application to the tribunal. As I say, there's a risk involved there, so a very careful consideration has to be given before proceeding. But there is cost involved with an application to the tribunal, so it is something to consider, at least in some cases. Now, moving on to the actual application of Section 84.1 Discharge and Modification, this is going to be a relatively brief, but I hope practical overview of that section, because the leading textbook, Preston and Newsom, on restrictive covenants affecting freehold land, devotes 8 chapters to the discharge and modification of covenants out of a total of 19. So getting on well over a third, getting on for a half of the book is devoted to discharge and modification. It's a big topic, in a topic which, restrictive covenants generally, which is already very big. So that shows what a lot there is to consider on these applications, but I've tried to break it down. The overarching requirements of an application to discharge or modify are, firstly, that you need to bring your case within, having got over all those jurisdictional questions that we've just been through. First question is, can you bring yourself within one of the grounds on which the tribunal has power to act? And I'll go on just in the next slide to consider what those grounds are. And if you can bring yourself within one of the relevant grounds, can you then persuade the tribunal to exercise its discretion to modify or discharge? It's not automatic. The tribunal does have discretion, even if you bring yourself within one of those grounds. And Jay is going to be talking about a case in which there was a question of conduct as to the applicant's conduct. For example, if an applicant knowingly disregards a restrictive covenant and builds anyway, and then subsequently seeks almost retrospective discharge or modification, the tribunal may well take a dimmer view of that. And even if they can bring themselves within one of the grounds, particularly if they can bring themselves within the main ground, the tribunal may refuse to act in any event. The tribunal does have to consider all the circumstances in deciding whether to exercise its discretion, or all material circumstances, and it's specifically provided that that has to include matters of planning. Indeed, if an application to build or develop or perhaps use the land in some other way requires planning permission, then an application will not normally succeed before detailed planning application has been obtained, because the tribunal wants to be able to see the actual proposal that is being made as to the reason why discharge or modification is required, and not speculate as to what might be involved. So it has to take into account certain planning matters, and it may require, effectively, planning permission, detailed planning permission to be obtained. So there's 4 grounds. I'm going to run through the first 3, especially briefly, for reasons which I'll explain, and then spend a little bit longer on the 4th one, which is what I've just referred to as the main one, perhaps the most important one, certainly the one that's most likely to be successful, and the one that Jay's going to talk about a little bit further in his part of the talk. There is some overlap between these grounds. You can see that if a covenant should be deemed to be obsolete, then that may well be because it causes no injury. It would cause no injury if the covenant was removed, and if it is obsolete and causes no injury, then it's likely not to be more than minor benefit and to impede reasonable user. So AC and AA, those are the subparagraphs, lettering, may well overlap. but they are separate grounds. They do require slightly different things. And whilst a lot of applications do pursue several of them in the alternative, it's got to be borne in mind that if you succeed on some but fail on others, then there could be adverse cost consequences. Ground A is that by reason of certain changes or other circumstances, the restriction ought to be deemed, the restrictive covenant ought to be deemed obsolete. Doesn't mean absolutely obsolete, but it ought to be deemed obsolete because of those changes or those circumstances. Relatively few applications succeed under paragraph A because it is quite a high hurdle to cross. But perhaps one circumstance where it may succeed, among others, is where a restrictive covenant has been breached in the past, and that breach has been acquiesced in, such that the court wouldn't grant an injunction to prevent further breach of the restrictive covenant anyway. And in those circumstances, the tribunal may consider that that restriction ought to be deemed obsolete because it wouldn't, although it is enforceable, it wouldn't be enforced by the court, and for that reason should be discharged or modified. As I say, there are other circumstances, but that may be one example. Ground B is effectively consent or agreement. If there's consent with the persons of from the persons of full age and capacity, from the time being entitled to the benefit of the restriction of various different interests in the property, and they have expressly or implication agreed to the discharge or modification, then the tribunal can act under ground B. That, given what I've said previously, is of potentially limited use, because if you've got an express agreement with everyone of full age and capacity, then you don't need to go down the tribunal route if you can execute a sufficient deed and register that deed. But this ground does give power to the tribunal to act where it can imply an agreement, which sometimes can arise where potential objectors, potential people with the benefit of the covenant who might object to the discharge or modification, either don't object or object and then withdraw their objection. In some circumstances, the tribunal can imply an agreement under ground B to modify or discharge, but otherwise potentially of limited use. Ground C is essentially to the effect that the tribunal can discharge or modify if the discharge or modified covenant won't injure the persons entitled to the benefit of it. Like ground A, that's quite a high hurdle to get over, and again, is not it's not common for this ground to succeed. In fact, as it has been pointed out in the textbook that I referred to, it's hard to see cases that would succeed under ground C that wouldn't succeed under ground AA, because if no injury is caused, then it almost follows that restriction secures no more than a minor benefit to the person with the benefit or supposed benefit of the covenant. So again, ground C is not a common one to succeed under. Ground AA is the most rather inelegantly called ground AA, but that's how it was amended in the statute. Is the most likely ground on which success can be found. It's quite a dense provision, covering several subsections or subparagraphs of section 84. In essence, distilling it right down, it requires that the person with the burden land is seeking to make some reasonable user of it, and that either the person with the benefit of the land has land which, in respect to which the covenant doesn't secure practical benefits of substantial value or advantage, or that reasonable user it would be contrary to the public interest to prevent that reasonable user taking place. So it's reasonable user plus either limited benefit or public interest, contrary to public interest. As I say, it's a little bit more complex than that, but that's sort of distilling it right down. That's the ground on which most often succeeds, because it's not such a high hurdle, it's not so absolute as something being deemed obsolete or there being no injury at all. For that reason, most of the cases plead this ground, and most of the learning and the law, certainly of recent years since this ground was introduced into the Act some years ago, is on this ground. That's the ground that Jay's going to be speaking further about. As I say, it's a fairly dense provision. There is a case called Bass's Application from 1973, in which the questions that need to be asked in respect of ground AA were broken down into these 7 questions, which is quite a useful guide, and the tribunals have sort of followed this guide since, but not all the questions need to be answered in every case. Some of them relate to, you can see that the first couple of questions relate to whether the user is reasonable, and then the next couple of questions relate to whether it secures practical benefits of substantial value or advantage to the benefited land. Question 5 deals with the alternative ground of public interest. And then question 6 and 7 deal with the question, which I'm going to come on to, about compensation, because compensation is most often awarded under this ground compared to the other grounds. And that may be a reason why some of the other grounds are relied on to try to avoid compensation. But as I say, this is the ground that most cases will succeed under, and compensation may follow. But those final 2 questions deal with that question, albeit that it's not really possible to separate this ground from the question of compensation. They're sort of tied in with each other, and perhaps that's why those questions are represented in this list of questions. Again, under this ground, one needs to take into account planning and other matters. And as I say, the question about the public interest is one that Jay is going to address further in a few minutes. I've referred to discharge or modification. Specifically, the tribunal is given power to wholly or partially discharge or modify restrictive covenants. The distinction between a partial discharge and a modification is unclear. I think, well, certainly to me, and I think generally, the precise wording may not necessarily be crucial, but you do have to be quite specific when making an application under these provisions. So if you're seeking discharge, you should say discharge, and if you're seeking modification, you should say modification. So it could have some import, and so it is worth spending some time thinking about exactly what you're seeking, albeit, as I said, it's not really clear what the difference between a partial discharge and a modification is. If the tribunal seeks to modify, then it can do so with the addition of further restrictions. So, for example, if it's willing to remove a restriction to allow a development to take place, it may impose other restrictions to avoid other problems arising from that development. Those additional restrictions have to be accepted by the applicant, but the tribunal can make them effectively a condition of the modification. So if the applicant is not willing to accept them, then the modification won't happen. In most cases, and particularly under ground AA, the tribunal will be looking to modify to the extent necessary to remove the impediment to the development that's provided by the covenant, and probably no further. If it doesn't need to remove a restriction, then why should it do so? And it probably won't. It'll probably go so far as necessary. Obviously, if it's discharging a covenant completely, that may be slightly different. On the question of compensation, this is the provision in the Act. It's actually a continuation of the same section, 84.1, dealing with compensation. Essentially, there are 2 heads of compensation on which the tribunal may award if it decides to discharge or modify. Under the second head there, that deals with where a property has, for example, been sold at a lower price because of a restriction that was taken over the land, which made that land less valuable. So if the tribunal then discharges or modifies that restriction, a sum can be awarded to make up for any effect which that restriction had in reducing the price that was paid for the land that is affected by it. Either under that ground, the tribunal can award compensation, or it can award compensation under head 1. That's perhaps the more interesting ground, and given that the second ground which I've just referred to, may be more limited circumstances in which that can be awarded. The first ground is simply for loss or disadvantage suffered by a person in consequence of a discharge or modification that's made. That will usually, therefore, be loss of amenity. But that will include diminution in the value of the land. If your land becomes less valuable because a restrictive covenant that you had the benefit of is discharged or modified, then you may suffer a diminution in value of your land, and the tribunal can award compensation for that, normally by way of a small percentage of the value of the land. So if your land has been, value of your land has been reduced by 3%, for example, by the discharge or modification of the covenant, or would be, then the tribunal might award compensation in that amount, together with any other loss of amenity. The one point that I would make about compensation is that certainly where it's allied to ground AA, which is the more common ground, ground AA only permits modification or discharge where a covenant secures little practical benefit, or little practical benefit, little substantial value or advantage. So a tribunal should only be discharging or modifying that covenant if there is that limited benefit, and therefore the compensation that's required to compensate for the removal of that limited benefit should in itself be limited. And it is true that if a tribunal finds itself in a position where it would have to award larger compensation, then it's unlikely to make that modification or discharge, because it won't have satisfied the ground AA that the benefit was limited. It rather indicates that the benefit is more substantial. So compensation in those sorts of cases can be relatively low, but it's something that has to be, again, something that has to be considered. And I'll finish by just saying a few words about procedure. In many ways, procedure is similar to the more familiar court process, but there are differences. For example, advertisement. Normally, applications that are made will be advertised to pick up any people who might claim to have the benefit of the covenant. The reason for doing that is because if the tribunal makes an order discharging or modifying the covenant, that will have in rem effect and bind people other than the parties to the application. So it needs to be particularly careful to try to get in all the people who, or notify all the people who might claim the benefit of the covenant. And therefore, advertisement is a step which is normally directed, which is rather different to the normal process. Where people do object, then there may be hearings to determine whether they actually do have title to the benefit of the covenant or not. And that's a sort of a preliminary step, quite apart from any other preliminary issues that might need to be decided of the nature that I've already mentioned. Following through the procedure leads to a final hearing and a decision and an order. It's worth mentioning this is a costs jurisdiction, so costs are in the discretion of the tribunal, albeit with some specific procedures to the or principles in awarding costs, which the tribunal will apply. So, for example, someone who objects to a discharge or modification but is unsuccessful may nevertheless find themselves not having to pay the successful applicant's costs unless they've behaved unreasonably. It is a discretionary power, that's only a principle, it won't necessarily apply, but there are particular practices to be aware of in respect of costs. And that's just a slide showing, a final slide showing the various rules and practice directions, standard forms, fees orders that one needs to be aware of when making an application to the Lands Tribunal. There's quite a lot of rules that follow, and one can also access decisions from the tribunal website, as well as other places. So there's plenty of material out there. And there's plenty of material out there because there's far, far more that could be said about this whole process. As I said, that the book on this is full of law and procedure and substantive law and so on, and a talk on this could really include a lot more. But that's a brief overview. Jay is now going to talk about ground AA, and in particular the public interest aspect of it.
Well, I'll move quickly through this slide because Michael's already taken us through this. The purpose of this slide is just to show ground AA. I appreciate there's quite a bit of text. What I'm interested in is the second limb, so the contrary to the public interest. Just one point I would make, because it's quite important to the case that I'm going to come to discuss, is that it's really important to go back to ground AA and some reasonable user, because the Court of Appeal, as upset as it was with the conduct of the applicant in the case that I'm going to come to discuss, seemed to have forgotten that, and the Supreme Court needed to remind them effectively that is, when one looks at the jurisdictional threshold, that we're coming back to that reasonable user of land. So contrary to the public interest and reasonable user are linked. Michael's already picked up on this, but the tribunal is actually mandated to consider the development plan, planning permissions, the context in which the covenant was created and imposed, and any other material circumstances, which is obviously quite broad. So taking us through the different questions that emerge from council submissions in Rebass's application, that council is now credited with coming up with all of these questions, which have been used in many other cases. So the first question is the proposed user reasonable? This is usually uncontroversial. It's usually agreed between the parties. It's rarely in dispute. All the applicant really needs to do is to propose a defined reasonable use of the affected land that the restriction impedes. The tribunal proceeds on the counterfactual of ignoring the covenant, which obviously makes sense. It's considering whether the proposal itself constitutes reasonable user of the land, and it doesn't really care what the objectors have to say about that. And it doesn't even really care about what the local community has to say about that. So I've referred to a case that involved a mosque. The proposal there was locally unpopular, so beyond the objectives. But that doesn't make a difference because the tribunal approaches it on an objective basis, counterfactual of ignoring the covenant. Planning permission will help. The absence of any prospect of obtaining planning permission might prove fatal to establishing those grounds. But as I've said, this question is usually agreed. And in the case I'm going to come to discuss, it was agreed, which is quite common. So the second question comes back to all the things that we're not discussing. It normally answers itself. If you've had to make an application, then presumably the lawyers involved have determined that the covenant itself does impede that user. So you're coming back to the questions of construction, enforceability, annexation. I've just made a note because this can be interesting, where you almost have hybrid approaches, because there can be disputes about construction, enforceability, and annexation, but it's not the tribunal that you generally go to resolve those disputes. So you could have a situation where those disputes need to be ventilated first in the court, and then once those disputes have been determined, you then can make a decision whether to make an application. Question 3 and question 4 concern the limited benefit test, and Michael's discussed that. I'm not here to discuss that because what I'm interested in is the public interest test. And some newbies to Section 84 might be forgiven for thinking, oh well, this is pretty wishy-washy stuff. I can just go to the tribunal and say, well, there aren't enough houses in this country. Obviously, you've been reading the papers, reading the news. I'm proposing to build some houses. It's provide houses in the community, that must be in the public interest and therefore accede to my application. Well, it's not that simple. And it's actually quite a narrow jurisdiction once you start digging into it. So the policy I've set out there, that's an extract from Lord Justice Carnwath, as he then was, from his judgment in Shepherd and Turner. It's referred to in many of the cases, and this is not intending to be disrespectful to Lord Justice Carnwath, as he then was, but it doesn't really tell you that much because it's a bit wishy-washy. Well, it's a balancing exercise. Well, that comes back to one of the first slides that I was talking about, the competing interests. And it's of the very nature that Parliament is intervening in what is effectively a matter of private law and private rights and contract, that there needs to be a balancing exercise between the public interest and the private interest. It's a demanding test, and Ree Collins's application is an important decision. That extract from his judgment is referred to. Now, in the case that I'm going to come to talk about, Alexander Devine, the Upper Tribunal actually doubted whether this was a correct statement of principle. The Court of Appeal went back to approve that statement as correct, and the Supreme Court were a bit silent on it, but I think the general direction of travel is this is still good law. So the important bit to take from that is it needs to be so important and immediate as to justify what is effectively a serious interference with private rights and sanctity of contract. And the final slide, you might need to read, sorry, the final bullet, you might need to read that a few times. It's actually quite a subtle difference, but it's an important difference. So the test isn't whether it would be in the public interest for the land to be developed in the manner proposed, but whether not developing it in that manner would be contrary to public interest. It's a subtle distinction, but it's a very important distinction, which goes back to the relatively restrictive approach to satisfying the jurisdictional threshold under this limb of ground AA. So planning permission. Question 1, it's important. Question 5, it's not as important. So obviously it would help, but it's certainly not determinative because it's not sufficient on its own. All that shows is that the proposal itself isn't actually contrary to the public interest, but it doesn't actually answer the threshold question. So more, and usually much more, is needed. And I've referred to Preston and Newsom. Both current editors are members of these chambers, but this is and one of them has just left chambers to become a judge of the first tier tribunal. But that is a pretty important extract to bear in mind when you're looking at public interest, which is you need to show effectively that the development needs to happen at these premises. So what that means is, if you're looking at housing, if there were other there are other plots of land in the local neighborhood which could be used for housing, then it's very unlikely you're going to be able to satisfy this limb. You also need evidence, and that evidence is likely, or the most persuasive evidence is likely to come from relevant people at the local authorities. So that all needs to be considered before making the application, and usually without the support of the local authority, it's going to be very difficult to satisfy the tribunal that the public interest has been engaged. So you only get to questions 6 and 7 if you can cross the jurisdictional threshold in principle. And Michael has already talked about this, and so I'll be relatively brief. There's an important difference of treatment depending on whether it's the limited benefit of the public interest test. You can see what I say about the limited benefit test that's consistent with what Michael said earlier, because if you've established the jurisdictional threshold, that actually the restriction itself confers a limited benefit, then it would be very difficult to contemplate a situation where money wouldn't be adequate compensation. And also it would be very difficult to contemplate a situation where the compensation would be high. Now, all of that is out of the window once you're into the world of the public interest test, because just because it's contrary to the public interest doesn't necessarily mean that the value of the restriction is de minimis, relatively low, and actually it could be quite substantial. So, as I said at the start, this is probably one of the sexier property cases that have been decided in recent times. It's important to consider the facts because that's where the real, if you're into aggravating factual matrices, then this is certainly your case. I'll take you through the basic facts. So the covenant was imposed in 1972. A farmer conveyed he conveyed land and he retained adjacent land. He imposed restrictive covenants. You can see the restrictive covenants there. They're pretty clear. Do not build any buildings or structures on the land that I'm conveying to you, and make sure you only use that land for the purposes of a car park. If we fast forward to relatively modern times, that land burdened by that covenant comes into the hands of a property developer. That property developer is fully aware of those restrictive covenants. He then goes about seeking and obtaining planning permission to erect 23 affordable homes. 13 of them were built, or at that stage were to be built, were built on the burdened land, with the remaining 10 built on adjacent unencumbered land. Now, the reason why the developer needed to build these affordable homes is because he had actually, or the developer, it had a substantial commercial development relatively close by. And as people who practice in this area know, the local planning authority said, well, if we give you planning permission for that commercial development where you're going to make a lot of money, then you need to build 23 affordable homes. And quite importantly, this developer could have applied for planning permission in such a way, and he could have constructed those affordable homes on the unencumbered land. So he didn't have to go there, but he did go there. And the LPA indicated that it would have granted planning permission so that he could have actually built all 23 homes on the unencumbered land and continued to use the encumbered land as a car park. So on the other side, when we look at the benefiting party, the farmer dies, he gifts, he bequeaths that land, the benefiting land, to his son gifts off some of that land to a children's cancer trust, and that children's cancer trust was obviously really grateful for the gift, and it intended to build a hospice for children with terminal cancer. The son was unaware of the application for planning permission. He only became aware of what was going on when there were preliminary works being carried out by the developer. He wrote to the developer, so this is at an early stage in the development, saying, what are you doing? There's restrictive covenants, you're breaching restrictive covenants. The developer obviously didn't really care too much because he continued with the construction work and completed the development. And it was only once the development was completed that he made an application to the tribunal. And just pausing there, it's about as aggravating as it gets. The Supreme Court toned down the language and referred to it as a cynical breach. The Upper Tribunal described it as opportunistic. And if you ever want to read a Court of Appeal judgment which is extremely, extremely critical of a party's conduct, then the Court of Appeal judgment would be a great starting point, because they went well beyond all of that. So in the Upper Tribunal, developer seeks to rely on AA and C. He relies on both limbs of AA. He doesn't satisfy the tribunal on the limited benefit test. And if he doesn't satisfy the tribunal on the limited benefit test, he's not going to satisfy the tribunal on underground C either. It was an ambitious argument given the effect on amenity on the planned children's hospice. Now, the Upper Tribunal was satisfied that the public interest test had been satisfied, notwithstanding what it described as high-handed and opportunistic conduct. So it was satisfied that the jurisdictional threshold had been engaged, and also that it ought to exercise discretion. It was very influenced by the grant of planning permission, the provision of social housing, and the fact that at this stage the houses were already built, and if they didn't accede to the application, then those houses would likely have to be destroyed, and that would cause a huge amount of waste. The problem with all of that is that the planning permission says nothing about respect for private rights and social housing, and the fact that the houses were already built was only relevant if the had engaged in what the Supreme Court described as cynical conduct. But you can see what the tribunal had to say. It's not in the public interest for these houses to remain empty. And the only obstacle to their occupation is the covenants. Unsurprisingly, it makes its way to the Court of Appeal. Unsurprisingly, the appeal was allowed. Now, the Court of Appeal said that both the jurisdictional tests and discretion dictated that the application ought to be refused. So the developer failed to establish jurisdiction, and also that the discretion ought to be exercised in its favor. And there's a reminder there in the second bullet about the point that comes from Marie Collins' application. This is quite a serious interference here, and Parliament really didn't intend for it to be exercised too broadly. So it approved the stringency demanded in Marie Collins, that extract which I've already showed you from Douglas Frank QC's decision. It was seriously unimpressed by the developer's conduct, and it considered that important to or relevant to the jurisdictional and the discretionary exercise. And it was for that reason, effectively, that the Court of Appeal determined that the application ought to fail. Now, there's a lot of text here. I'm not going to read through it, thankfully, given where we are. But that text, and I should say you will all receive these slides after the presentation, just gives you an indication of just how angry Lord Justice Sales was in describing the conduct of the developer. In the Supreme Court, as you'd expect, the language is toned down a bit. Cynical breach is what it's referred to. So as I said at the start, it's a big deal in the Section 84 world, because it's the first time that Section 84 has been considered by the UK's highest court. The appeal was dismissed, but for different reasons. So what the Supreme Court considered was, well, you can't consider all these other circumstances, the cynical breach, as part of the jurisdictional exercise, because actually the jurisdictional assessment is relatively narrow, because you're coming back to reasonable user, and it's reasonable user that's the question. So all of that other stuff is important to the exercise of discretion, but it's not important to the exercise of jurisdiction. So there was a problem here, because there were competing land uses, and actually what they considered was that the Upper Tribunal was right, and that it couldn't be faulted as an error of law, because what they had to do was balance the fact that you had social housing, these houses were already built, there would be huge wastage, against the effect that all of that had on the planned children's hospice. So they couldn't interfere with the Upper Tribunal's decision on jurisdiction. But as a matter of discretion, they agreed with the Court of Appeal that the discretion ought not to be exercised in the developer's favor. So there's no absolute principle that whenever there's going to be a cynical breach, that discretion ought to be exercised against the applicant. And the only way that an appellate court can interfere with an exercise of discretion is if there's effectively a serious error of law. And the Supreme Court found that there was a serious error of law, because there were two important factors which hadn't been recognized by the Upper Tribunal, or indeed the Court of Appeal, at least not overtly. And that's the fact that, as I said right at the start, in the factual matrix section, this developer could have actually applied for planning permission on the unencumbered land. He could have constructed the affordable homes without needing to actually make an application to discharge the restrictive covenants. And number two, it's very linked. He had given the tribunal the fait accompli, which actually, because he had engaged in the cynical breach, he had actually helped his application, because he's going to the tribunal and he's saying, well, look, the houses are being built. We can't destroy them. That would be hugely wasteful. And had he not done that and actually made his application like a normal person before actually carrying out the development, then it's very likely that he wouldn't have succeeded, because the objectors would have said, well, you don't need to modify your discharge, because you can do this on adjacent land, and the local authority will give you planning permission to do that. So you don't actually need to come to the tribunal to modify your discharge. And you can see from the extracts that I've cited there, you can see what the Supreme Court had to say about that, which is consistent with what I've just said. So in terms of winners and losers, just really quickly, as I've said, and it should flow from what I've already said, the tribunal was right to determine that the jurisdictional threshold had been satisfied. It was contrary to the public interest, heavily influenced by the facts which I've already said. The tribunal was wrong to exercise its discretion, notwithstanding the cynical breach. The Court of Appeal was more wrong than the tribunal, it turns out, because they were wrong to determine that the tribunal had erred in law in its approach to the jurisdictional threshold. The narrow focus, as I mentioned, is the approach that you need to take to jurisdiction, and cynical conduct isn't relevant to jurisdiction. But the Court of Appeal was right not to have exercised its discretion, but it was wrong to do so for the reasons it gave, because of the two factors which I cited on the previous slide, which ought to have ruled the day in the Court of Appeal. So it's an extreme case. I think this is actually really quite interesting because of the narrow approach. It's leaving a lot of the heavy lifting to discretion, and the question is, can discretion do that heavy lifting? Because there are some problems. There is case law out there. It's that trustees of the Green Masjid case, that once you've satisfied the jurisdictional threshold, it ought to be effectively a rare case where discretion isn't exercised in favor of the applicant. So that's case law that future tribunal decisions have to deal with. And an appellate court can only interfere with an exercise of discretion where there's been effectively a serious error of law. So my concern is you could have a hypothetical counterfactual, which might be slightly different, maybe along the lines of what I've suggested. And the question is, if the jurisdictional threshold would be satisfied as it was in Alexander Devine, will the discretionary stage be good enough to protect the objector's interests? And there could be cases where it's just not possible as an exercise of discretion to refuse the application when the jurisdictional threshold's been satisfied. And just an important reminder about the limits of the jurisdiction. I've already made this point. So after all of this, all the way to the Supreme Court, all that was determined is that the covenant wasn't to be modified or discharged. They didn't deal with relief, and Lord Burroughs made that point in the final paragraph of the judgment. I don't know what's happening, but there might be an application for an injunction or damages in lieu of an injunction. There's very likely, it's going to be a very interesting case because this is kind of the archetype situation for exemplary damages. How those damages are quantified if the court is prepared to grant damages in lieu is a whole nother matter. Maybe the parties are negotiating, but it's very likely after all of this, there's going to be a huge compensation payment in the light of the developer's cynical conduct. So I appreciate we've overrun. The last few slides are extremely quick. It's just to show trends. Like most first instance decisions, there's very little precedential value. And one of the difficulties in this area is kind of understanding in advance how the tribunal will approach an application. The first one is just a trend that, and it's pretty obvious stuff, that modest proposals such as barn conversions and the like are more likely to satisfy the requirements of a successful application. So I've referred to two cases there. I'm not going to go through the details of those cases. You can access those cases if you're interested in them. But the fundamental point, and it's an obvious point, is that the more modest the proposal and where the use itself actually on the face of it looks like it's going to improve things, the more likely the tribunal will exercise its jurisdiction to modify or discharge. Now, the converse of that is also very obvious. It's extreme proposals. And you can see from these two applications, an 83-bed care home, a 25 resident care home, footprint 3 times that of the existing house. I mean, you don't have to be a rocket scientist to realize that those applications are at the extreme end. But it comes back to the point that I was saying, which is Section 84 is not the solution to everything. It can only work so hard, and it's actually much more tempered than people might first think. then finally, in our final slide, is just recently created covenants. The tribunal generally doesn't like people coming to the tribunal within a short period of time of the covenant having been imposed. Your better, more successful kind of arbitral cases, old covenants where things have changed considerably since the covenant was created. But yes, the tribunal will not be very impressed if only a few years after the covenant has been created, you come to the tribunal asking the tribunal to modify or discharge. So it's all very obvious stuff. And that concludes our webinar. So thank you very much for joining us. Sorry for overrunning by a few minutes. We started a few minutes late. As I said, our clerks will be circulating a copy of those slides. I appreciate there's a lot of content, but you will all receive a copy of those slides. And if there are any questions, we'd be really grateful if you can put them forward to us. You can use the chat function, or if you think of a great question after the end of the webinar, you can obviously contact either Michael or I, and we'll do our best to try and answer the question. So please do filter through any questions if there are any. I can see that there are a few questions actually. So just running through them, hopefully chronologically, I can see that Andrew Cox asked a question quite early on. So insure against what? And I think that relates to your bit, Michael, and I presume what you were talking about was indemnity insurance?
Yes. I think I addressed this at the time, but yes.
Good. So, and I think the point Michael was saying, you know, we can get indemnity insurance, but that potentially can only protect you so far, and you know, you still need to consider the situation quite carefully before going on to develop land in circumstances where you know that there's a potential problem. So Ian Thomas has asked a question for ground B. Are there any requirements for the consent? Ooh, that looks like a tricky question. I can see Section 2 of the 1989 Act has been mentioned. Michael, do you have any thoughts on that?
I've answered that one in the chat, Jay. I think that
Okay.
The tribunal can make an order even on the basis of implied consent in the right
That's right.
circumstances. So that wouldn't necessarily comply with Section 2. But if you are avoiding the tribunal and making your own agreement and deed, then outside of the tribunal process, then you will need to comply with all the relevant formalities.
Good. And sorry, I didn't see your answer. And for what it's worth, I agree with you. It'd be pretty strange if the tribunal could give effect to an implied agreement, and at the same time turn around and someone could argue that Section 2 hasn't been satisfied. But it's an interesting question. Are there any other questions? Well, should we leave it there, Michael? As I said, if there are any questions, both Michael and I would be happy to do our best to try and answer them. So just contact us either through our clerks or directly. And once again, thank you very much for joining us this morning, and best wishes going forward and for happy and healthy holidays. Thank you.